We close the chapter with a venue students often overlook in the politics of interest groups, the courts. Litigation has become one of the primary strategies through which interest groups pursue their goals, and understanding this is essential to understanding modern American politics. Why courts? Because the judicial branch operates on a different logic than the legislative or executive branches. Where legislative success requires building majorities, judicial success requires persuading judges of constitutional or statutory propositions. A well-funded interest group with skilled lawyers and a long-term strategy can sometimes achieve through the courts what would be politically impossible to achieve through Congress. The paradigmatic example is the NAACP Legal Defense Fund's litigation strategy that culminated in Brown v. Board of Education in 1954. We covered this in Chapter 7. Thurgood Marshall and his colleagues spent decades methodically building cases that progressively narrowed and finally overturned the Plessy v. Ferguson doctrine of separate but equal. It was a textbook example of strategic litigation as a tool of social change, and it has been widely replicated across the ideological spectrum in the decades since. Civil rights groups continue this tradition. Environmental organizations use litigation to enforce statutes like the Clean Air Act and the Endangered Species Act. Business associations litigate to challenge regulations. Religious liberty advocates have pursued an extraordinarily successful strategy in cases like Hobby Lobby, Masterpiece Cake Shop, and 303 Creative. Gun rights advocates achieved one of the most dramatic doctrinal transformations in modern law through Heller and Bruin, and reproductive rights opponents pursued the multi-decade strategy that ultimately produced Dobbs. The primary vehicle through which interest groups participate in appellate litigation without being parties to the case is the Amicus Curiae brief, the friend of the court brief. By submitting these briefs, organizations provide the court with information, arguments, and perspectives the parties themselves may not have fully developed. Just as importantly, amicus briefs signal to the justices the range of constituencies affected by their decision. Major Supreme Court cases in contentious areas, gun rights, reproductive rights, affirmative action, LGBTQ+ rights, campaign finance, routinely attract dozens or hundreds of amicus briefs from organizations on all sides. That makes the Supreme Court's decision-making process an extension of the interest group competition that occurs in the legislative and executive branches. Let me close the chapter by stepping back. Madison feared factions and built constitutional structures to control their effects. The system has partly succeeded and partly been overwhelmed. Parties have organized democratic competition and accountability in ways Madison could not have anticipated. Interest groups have institutionalized influence, both for groups long excluded from power and for those who have always had it. Money has become the connective tissue of contemporary politics. The question whether the resulting system genuinely represents the people or has become a system in which organized factions, especially well-funded ones, exercise disproportionate influence is one Madison would still recognize, even if the specific institutional forms would astonish him.